When someone's thinking about contesting a will, it really comes down to why they're contesting the will. Sometimes they're questions about validity of the will, and sometimes they're questions about what the will actually provides for them or doesn't provide for them. And often when it's the latter, they're thinking about whether or not they might have a claim to seek further provision.
A family provision claim is a claim that a person makes when they want to contest a will. When they're not happy with what they receive under a will, or they haven't received anything under a will, they can make a claim to the Supreme Court under the Family Provision Act to receive further provision from an estate. Not everyone is an eligible claimant. To be an eligible claimant, you usually have to be some sort of relationship with the deceased person. So it might be that you're a wife, a spouse, a child. Some grandchildren can make claims in certain situations, but not everyone can make a claim.
What sometimes surprises people is that people that they have long separated from but continue to be their legal spouse are still eligible claimants under the legislation. WA's categories of eligible claimant are somewhat narrower than some of our counterparts in the eastern states, so it's very important that anyone considering a claim makes sure that they're receiving WA-specific advice, tainted by some of the broader concepts in other jurisdictions.
Ex-partners can make claims, but it depends if it was an ex-wife and they're still married. If it's a de facto partner and they're no longer in a de facto relationship, or they weren't in a de facto relationship at the date of death, then they're not eligible to make a claim.
Often people think that family provision claims are about achieving fairness, but that's not the intention of the legislation. The legislation exists to ensure that adequate provision is made for eligible claimants, and adequacy does not always equate with fairness in some people's eyes. But the courts often say that they're not there to disrespect the testamentary intentions of the will maker, but it is always a balancing exercise between what the will maker wanted and meeting their legal and moral obligations.